Shakotiia'takehnhas Community Services issued a press release recently advising of a Quebec law which will have a direct effect on their ability to offer childcare services to the community. We speak to KSCS Executive Director Derek Montour and Grand Chief Mike Delisle for an explanation on this situation.
The law came into being in 2009. Unfortunately, we didn't hear a whole lot about it. We didn't know much, and not just we as in Kahnawake, but most of child welfare services throughout Quebec didn't hear a whole lot about the impact of this law. Really, within the last year or so have we started getting a better sense of how it's going to be implemented and how it's coming along. To put it simply, Law 49 involves the unionization of foster homes. So essentially, foster homes throughout Quebec can now be represented by a union or an entity. They had different reserves for it, some type of representative. Ultimately, the reasoning is in order to ensure foster homes are being paid appropriately. Ultimately, that's what it is. Some of it is to also ensure that the foster homes are providing adequate care to the children. That we can't argue with. Even with the appropriate compensation, we can't argue with. But how it's being implemented has some severe potential undermining effects to Kahnawak's social fabric. What this law does is cause all our foster homes, including grandparents, to have to become members of the union and to have to work for the province of Quebec. That has some large implications for a number of reasons, most namely our own sovereignty.
This Bill 49, it's a problem that we foresee, that they've foresaw for quite some time in terms of how they're going to deal with not only childcare but placements and services basically in the community that the community's been dealt with for many years now and have been successful in. We don't like to see child placements, but unfortunately they need to happen. Here now it seems that a delegated authority once again from the federal government is going to hamper service in Kahnawake.
Ultimately, this process to me is unacceptable for our community. What I would first like to seek from Quebec is an exemption of the applicability of Law 49 in the community of Kahnawake. Whether they do that or not, because there's a lot of debate, particularly right now with some court decisions that are happening on who has jurisdiction within First Nations communities, the province or the Canadian government.
So we're going to engage with Quebec first, but I mentioned at the board, of which I'm a member now, appointed by council, at Community Services, that I think the real direction is to go after the feds. So we'll do that as a second motion, if you will, to go after the federal government and say you can no longer continuously delegate authority when it comes to something as specific as this and has such a detrimental effect in Indian country, if I could say that. So two levels of action that will happen. The first one's already been initiated.
This law may cause us to lose foster homes in general, may cause us not to have additional foster homes, and may cause us then to have to place more and more children off the reserve. In the last 10 years, we went from 95% placement rate off reserve to 95% placement rate on reserve. This law has the potential of totally reversing that.
Because we've been successful, and I hate to use that term in terms of child placements in the community and trying to maintain our people within the territory, so to speak, this can have major repercussions, not only for the workers because of union issues and so on, but on the ground, the kids, the children, the young adults who will be affected by this and may possibly have to be placed elsewhere. Absolutely, the community should be concerned not only with this imposition, but any other imposition of provincial law in Kahnawake.